This week in U.S. immigration news, we are going to cover nurse shortage could be cured by immigrants, age-out protection for those in USA. The demand for nurses is especially critical and is expected to worsen when thousands more leave the workforce in the next 5 years. According to a new report by the American Immigration Council on the economic contributions of immigrants in Ohio, job postings for registered nurses rose 62% and 187% for nursing assistants between 2017 and 2021. There are many qualified immigrants who could help fill those roles. However, the U.S. immigration laws are too strict. Medical boards are set by each state and they are too restrictive. There needs to be pathways that allow them to apply their experience and coursework towards a license. It doesn't make sense to ask an internationally trained nurse with 5 to 10 years of experience to go back to nursing school to take basic classes. Some possible solutions should include offering intermediate licenses or awarding credit for professional experience or requiring targeted professional development. This could bridge the gap between the need for qualified workers and the supply of people who are ready to help. 21 Republican states have sued the Biden administration to stop the new humanitarian parole program that started in January. The program allows up to 30,000 people from Cuba, Haiti, Nicaragua and Venezuela to be admitted into the U.S. each month, or urgent humanitarian reasons or significant public benefit on a case-by-case basis. Under the program, migrants are allowed to stay in the U.S. for up to 2 years and must go through an online application process, have a financial sponsor and undergo background and security checks. Almost 160,000 Cubans, Haitians, Nicaraguans and Venezuelans have arrived under the parole program through the end of June. The humanitarian parole measure is part of the Biden administration's expansion of legal immigration pathways that temporarily allow people fleeing political and economic instability to come to the U.S. The 21 states argued in their complaint that the policy was unlawful because it exceeds the federal government's statutory parole authority and does not meet the criteria for being used only on a case-by-case basis for urgent humanitarian reasons or significant public benefit. The states also argue the policy will cause irreparable harm to the states by straining their resources. Stay tuned to greencardguys.tv to follow the outcome of this case. Is your adult child over 21 and prevented from getting a green card due to the February 2023 policy change? Good news! On February 14, 2023, USCIS issued policy guidance to update when an immigrant visa becomes available for the purpose of calculating an applicant's CSPA age. USCIS now considers a visa available to calculate CSPA age for these applicants. At the same time, USCIS considers a visa immediately available for accepting and processing the adjustment of status application. The problem: before February 14, 2023, an immigrant visa was not always available to calculate CSPA age at the same time a visa was available to file an adjustment of status application. As a result, USCIS could not yet calculate the non-citizen's CSPA age because a visa had not yet become available under the prior policy, or USCIS would have calculated the non-citizen's CSPA age to be over 21 years old. Some non-citizens may not have filed an adjustment of status application as a result of these circumstances. Therefore, some of these same applicants, who have since filed or may now file an adjustment of status application under the new policy, may be unable to meet the 1-year sought to acquire requirement, unless the applicant establishes that their failure to meet the requirement was the result of extraordinary circumstances. Furthermore, some applicants, who met the sought to acquire requirement when they filed their adjustment applications under the policy guidance in effect before February 14, 2023, may no longer meet the requirement under the February policy. To address these issues, USCIS updated policy guidance to clarify that USCIS considers the February 14, 2023, policy change to be an extraordinary circumstance that may excuse an applicant's failure to meet the sought-to-acquire requirement, provided that the delay in filing the adjustment of status application is reasonable under the circumstances. The reasonableness of the delay is determined from August 24, 2023, the date USCIS is publishing this policy, considering the February 14, 2023, policy change to be an extraordinary circumstance.
Friends, show us some love and smash the like button. It doesn't cost you anything. If you have an immigration problem or need a second opinion because you cannot get a hold of your own lawyer, schedule a meeting with our team. Share information with our cares team and they will help you get scheduled with our legal team. Now here's a secret code to unlock the free 15 minutes.